Hello, I'm Frank Congilose. Welcome to the Institute of Responsible Wealth. Our guest today is Bob Muñoz, partner in Lomurro Davison, and our conversation today is going to be on the recent estate tax changes and what everybody's living with nowadays. So, Bob, welcome. It's always great to see you. And
thanks for inviting me
to our little show here. And the topic of estate planning covers so many different aspects of finance of people's lives and so forth. As it relates to that, what do you see as the two biggest objectives that people have as it relates to their estate planning and what they should be thinking about?
Well, two things we look at. We look to save taxes, but we also want to achieve the objective that the person has in terms of how they want to spread their wealth around in the event that something happens to them. How they want to plan for their family, or plan for their business, or plan for the support of other people they care about.
Every time we turn around, we see a tax law change, and it seems like it's always a moving target as to what's happening in the world of taxes and estate planning. And at the end of last year, it was kind of like a fire drill that went on, but they came out with some changes that occurred with regard to the tax law. And maybe you can share with us what those changes are and how they affect everybody.
The main changes last year was, as you recall, we were coming to the expiration of the so-called Bush tax cuts, which meant that we were going to go back to the $1 million exemption. And rather than going back to the $1 million exemption, Congress intervened and brought in the new $5 million exemption, along with some other changes. We had never anticipated, most of us as tax lawyers, that we would get to the point where we were going to actually see the expiration of the tax laws, but we came dangerously close.
When we look at that, it was like last year in 2010. There was no estate tax last year. It happened to be the year George Steinbrenner passed away. A very wealthy individual, and his assets passed from what it sounds like estate tax free.
Well, technically that's not true. Technically, the new law is retroactive to last year.
Oh.
But if the person died last year, you have a choice of which law you want to use. But there's a downside to using the untaxed estate approach as opposed to using the $5 million exemption. So it really is up to the individual estate.
Let's just highlight a couple of things with regard to some of the changes that took place. One of the things that we used to do a lot of planning with was this unified credit, which was the ability for someone to pass assets tax-free and so forth. And in the past it was like kind of a game that you had to play, or you had to do a lot of work in order to get that to work. What are the changes that were made as it relates to the unified credit?
Well, the unified credit has now gone to $5 million, which for most people will cover most of their estate. And then when you have spouses, it's $10 million. And at the federal level, spouses means the traditionally married couple. Doesn't mean any other alternate lifestyle arrangements. In New Jersey, at the state level, we do recognize other arrangements. But for the federal, it's $5 million each, and that will cover most U.S. citizens. The problem is that there's not a congruity between the New Jersey law and the federal law, and as a result we have other results that occur.
Stay with that, other results that occur. What specifically?
Well, New Jersey's exemption is only $675,000, which means that unless you pass it all to your spouse, or in New Jersey to a domestic partner, you will have to pay tax. And the threshold is much lower at $675,000, and in fact would probably affect most New Jersey residents. If anyone had a $500,000 life insurance policy and a $500,000 home, you're already over the $675,000.
So as it relates to estate planning, when people think of taxes, it's just not a federal estate tax issue. There's also, each state has their own set of taxes, which is, if you don't pay attention to it, it can catch you.
Yes, and in New Jersey we'll have people who have different situations where they have a house in Florida, they're residents of New Jersey, and we have to even do additional planning. Florida does not have an estate tax, but has other issues that we have to deal with.
With the law that changed, okay, what's the time frame, as far as for the new law that's in place?
The new law is for 2 years.
Okay.
And thereafter we don't know what we're going to have. We will then have another sunset back to the $1 million provision.
Knowing that we have a 2-year window at this point, we as advisors think that it creates an opportunity for people.
Well, it creates an opportunity for those who die in the next 2 years, but for those who plan on living beyond the next 2 years, the opportunity is in the gift-giving area. The gift tax and the unified credit for death have been reunited, meaning that at one time the gift tax was at $1 million exemption and the federal estate tax was at $3.5 million, for example. Now they're both $5 million. There's an opportunity to give $5 million away, not just $1 million. So you have a unification of the two taxes again.
As it relates to business owners specifically, are you seeing a lot of business owners starting to act on that, maybe doing some of their business succession planning?
I think that part of the problem is the business owners are somewhat enthused about it, but their concern right now is that business isn't doing real well. So the issue of valuation is a sticky question. And then the other part of it is that if the law goes back to $1 million, they may have what's called a clawback, which is if they gave away $5 million and then they were to die when the exemption is $1 million, $4 million of that might get reconsidered again in terms of estate tax. So what they thought they were giving away without any taxation will now be taxed at the estate tax level. So there is some concern.
You said something that was interesting with regard to business values being lower right now because of the economic crisis that we've had over the last couple of years. Would that create more of an opportunity, though, to do some planning?
It certainly does, but oftentimes the business owners don't see it that way. Certainly if a business owner came in to see me with the valuations I have today, I would encourage them to act now so that they could actually freeze any revaluation that might come in the future through inflation or through the business improving.
What are some of the issues that the business owners that you're seeing they're concerned, and is it feasible to give them what they want, give them the best of all worlds?
Well, there's a couple issues. One is the valuation issue that we touched on. One of them is the control issue, and we can give them that through various devices that we can use, either through trusts or through LLCs or family limited partnerships. Sometimes they get into trouble with valuation if you try to get too much of a discount, but we can even get discounts if we stay within the guidelines that the IRS provides and get them discounts on the gifts. So for example, everyone has a $13,000 annual exclusion, and if couples double up, you have $26,000. You can start giving away assets from the business by giving shares of the business, but getting a discount because they lack control. So at the end of the day, the owners of the business can continue to have control, continue to make money from the business, but start to give away some of the future interest to the children presently so that they have an opportunity to take advantage of the gift provisions. The $13,000 a year exemption doesn't count towards their state tax exemption and doesn't count towards their $5 million gift tax exemption.
It sounds like it's almost an automatic. Like if we were playing Monopoly, it's like you're going around, and every time you go around you get a couple $100. Each year, people have the opportunity where they can shelter that $13,000 or $26,000. I guess that's per person.
Per person annually, yes.
Very good. Mm-hmm. And in doing that, when they're making that gift, it doesn't have to be cash.
Well, that's right. It could be an interest in a business. It could be simply a book entry in a business.
So it's almost like if you don't do it, you're missing it. It should be an automatic, and most people's estate planning.
Yes.
We mentioned the tax side of it. We mentioned a little bit about the control side of it. But if I just touch on the asset protection side of, estate planning and so forth, we live in a society today where the divorce rate is 50%, depending upon what state you're in and whatever the case might be. And for a lot of people, although estate tax planning is important, protecting your life's work so it doesn't end up in somebody else's home or financial checkbook is very important. What do you see in there, and are there ways that people can protect themselves on that?
Well, one of the things we always talk about is trusts in wills to protect children from bad marriages. And one of the things that we always discussed is what is the child's marital situation when we meet. The other thing that we talk about is we sometimes create trusts that the children can use optionally to shelter their own money in the absence of a prenup. In New Jersey, if you inherit property and you keep it separate, it doesn't become marital property. So once you commingle it, it becomes marital property. So what we've recently been using a lot is a trust within the will that's at the option of the child to leave the property in the trust and not take the property outright, so that they actually protect themselves from a bad marriage or from some other claim later.
So for an individual, whether they own a business, don't own a business, or whatever the case might be, there are different legal tools, whether it be the wills, a business succession plan, or trusts, that really can give someone, the best of all worlds, which is, whatever it is that they're looking to accomplish.
They just have to be ready to roll up their sleeves and work at it and think about issues that they haven't thought about. One of the most difficult parts of doing this type of planning is creating all the scenarios, placing them in front of the client, and having the client think about them. And every time the client thinks they're done, you give them another little twist on the scenario. And I think they need to go through that. It's sort of it's a discussion, it's a conversation. If they don't have the full conversation with themselves and with their attorney and their other financial planners, then they're doing a disservice to themselves, and they won't have all of the answers. Instead, they'll find that out because they heard that somebody else at the country club had a different situation planned for them. So it's an important conversation to have all the what ifs.
As we're speaking here today, one of the things I like to point out to everyone is that when you're doing your estate planning and so forth, as you can hear from our conversation, it's important that you talk to people that specialize in a particular area. Because if I was dealing with a general practitioner, it's someone who's doing real estate closings and I don't think that we're getting the depth of conversation that I'm listening to today. And it's not taking away from anyone, but it's just, it is a specialty area.
But one of the other things I do is I do estate administration and estate litigation, and I litigate a lot of those situations where the documents haven't been done properly, and oftentimes it's because the person was not a specialist.
When we talk about the documents that can be done and the planning that can be done, we know that ownership of assets has a lot to do with the estate planning. Maybe you could take a few moments and tell us a little bit about why asset ownership is important and what we should be looking for.
Even if you had the best plan in the world, if you don't have your assets properly distributed, you can't actually activate the plan. So for example, if you had one spouse who was usually, let's say it's the working spouse because the other one has stayed home, if that spouse has all the assets in their name and the other spouse dies first, then there's no ability to take advantage of the tax planning because there are no assets to do that. Also, I try to discourage clients from having all of their assets jointly. I like to be able to identify those assets that are to be distributed, but in order to have them properly set up with the right plan, the assets have to be owned by each spouse in some form or another. My preference is separately, but jointly is okay, so that we can do some post-mortem estate planning if things change, through disclaimers or otherwise. Fortunately, at the present time, the federal law provides for portability of the exemption from spouse to spouse. So in my initial example, if one spouse had all of the assets but the non-asset spouse were to die, the portability would allow the $5 million exemption of that spouse to be carried over to the other spouse, which is very interesting at the federal level, but not very interesting at the state level because New Jersey does not have that portability. So the $675,000 exemption would not carry over. If you don't use it, you lose it. So that's why having the assets properly placed and also making sure your documents are up to date is important, because otherwise you could have issues. So for example, a lot of the older wills will say, I want the exemption up to the federal amount but not to exceed the state exemption. New Jersey didn't have an exemption 10 years ago. The 675 was not in play. Now it's 675, so if the documents were to have a $5 million exemption but are capped with the state level at 675, the plan is blown up. So as a result, that's one of the other reasons you have to take into account all of the issues and understand that although there's wonderful things like portability at the federal level, there is not at the state level.
So to summarize our conversation today with Bob, a few things you really need to look at. First thing is you need to get the right plan done. Second thing that you need to do is you got to make sure that your documents are aligned with your goals and objectives. You have to review your asset ownership and as well as your beneficiary arrangements to make sure that everything's consistent, it works together. And the last thing that I recommend to everyone who's watching is you really need to speak to a qualified professional, someone who really does specialize in estate planning or business planning. And for the business owners that are out there, your business is typically your largest asset, and you may spend 30, 40, 50 years of building it. It really deserves the attention with regard to planning its succession and what you're going to do with it. So Bob, I thank you so much for your time and for your input today. And
thanks for having me.
It's always a pleasure visiting with you, so thank you.